History as it happens, February 1st, 2024. Skokie.
Party members have made Skokie a target. They want to hold demonstrations there and pass out some of their abundant anti-Jew, anti-black literature.
Your Honor, this is a classic case in which government officials are asking a court of equity to impose a prior restraint on the speech of persons advocating unpopular ideas.
A car plowing into a crowd of demonstrators protesting against those white nationalists. A 32-year-old woman killed.
You will not replace us.
We're honoring the founding fathers who were white. We're honoring all of the great white men.
At Harvard, does calling for the genocide of Jews violate Harvard's rules of bullying and harassment? Yes or no?
Today's angst and anger over, or outright hostility to, free expression, the right to destroy your own reputation, is not new. These battles predate the founding of our republic, but the one that may speak most directly to us today took place in the 1970s in a suburb of Chicago when Nazis asserted their rights under the First Amendment. Why Skokie still matters, next as we report history as it happens, a podcast from the Washington Times. I'm Martin DeCaro.
Neo-Nazis ultimately decided that they were going to try and host their rallies in all the white neighborhoods outside of Chicago that whites were moving to from downtown Chicago, and so they wrote a number of letters to all these cities requesting a permit to rally. Most of these cities ignored them, but the city of Skokie reacted like a bull to the red flag.
You'll remember in December, Republican Congresswoman Elise Stefanik conducted a show trial of university presidents by asking a seemingly simple yes or no question concerning the pro-Palestinian demonstrations taking place on campuses nationwide.
At MIT, does calling for the genocide of Jews violate MIT's code of conduct or rules regarding bullying and harassment? Yes or no?
Whatever one thinks of the Congresswoman, the answers the trio of academics gave about antisemitism and provocative speech left a lot of people cringing.
If it is directed and severe or pervasive, it is harassment.
So the answer is yes.
It is a context-dependent decision, Congresswoman.
It's a context-dependent decision. That's your testimony today. Calling for the genocide of Jews is depending upon the context.
The university presidents were right that day. Elise Stefanik was wrong. But the fact that the speech is violence, speech is harassment argument was now being turned against the kind of people, liberal academics, who've deployed it against the right, was no surprise to me. It was simply a matter of time before leftists got a taste of their own medicine. And why I tell people who can't seem to understand this that censorship cannot be targeted against only the people you disagree with. Censorship boomerangs. Speech is violence or will cause violence or hurt your feelings. That claim can be used to silence any political speech, because political speech is by nature controversial. Remember Skokie? Wait, you don't remember Skokie? Here is the AP archive to help us out.
Skokie's 70,000 middle-income people have attracted a lot of business, but Skokie has also attracted a neo-Nazi group and a lot of controversy. The National Socialist Party headquarters are on the other side of town, far away from Skokie, but the distance hasn't eased the tension. Party members have made Skokie a target. They want to hold demonstrations there and pass out some of their abundant anti-Jew, anti-black literature. Skokie officials have blocked Nazi demonstrations with court injunctions. When the Nazis appealed to the state Supreme Court, the judges refused to hear the case.
A man by the name of Frank Collin of the Nazi Party of America. In 1977, he wanted to hold a rally in Skokie, Illinois, home of thousands of Holocaust survivors with a large Jewish population overall. So how could anyone want to defend him? Well, the ACLU defended the Nazis' right under the First Amendment to hold a rally in Skokie, and the case soon made national news. And led to a pretty decent made-for-TV movie in 1981, where the actor playing ACLU attorney David Goldberger argued that Nazis have the same right as anyone else to hold a rally, that they could not be censored without violating the Constitution.
Your Honor, this is a classic case in which government officials are asking a court of equity to impose a prior restraint on the speech of persons advocating unpopular ideas. Now, the village of Skokie has shown only that the political views of Collin and his party are offensive and outrageous, which of course they are. They have failed to show any reason to believe that the defendants plan to engage in any sort of illegal activity whatsoever. The question of violence has been repeatedly raised here, but that threat of violence comes not from Collin and his party, but from others who would keep them from exercising their First Amendment rights. Now, Your Honor, the legal scholar Harry Calvin called this a heckler's veto.
I thought of Skokie after the Unite the Right rally in Charlottesville, Virginia, back in 2017.
Streets of Charlottesville today, the hate boiling over, white supremacists and countered protesters fighting with fists and clubs. Confederate flags on full display. The governor declaring.
Well, after what happened in Charlottesville, I found myself arguing with people who said white supremacists should be barred from holding rallies anymore because their words are violence. And in Charlottesville, there was deadly violence. So, with an alleged white supremacist in the White House and our democracy in peril, the argument went, we had to think differently about the First Amendment. Free speech, in other words, is dangerous. That same argument was made in the Skokie case in 1977.
This threatened march by Nazis is a deliberate attempt to exacerbate the sensitivities of the Jewish population of Skokie and to incite racial and religious hatred. It is an incitation to violence and retaliation.
The group now leading the defense of free expression goes by the acronym FIRE, the Foundation for Individual Rights and Expression. FIRE's executive vice president is Nico Perrino. He co-directed a documentary about Ira Glasser, who led the ACLU for 23 years, starting in 1978, the year after the Skokie case went to court. The documentary is titled Mighty Ira. It deals with Skokie with some amazing archival footage. It is available on Amazon Prime Video, among other streaming services. Nico Perrino, hello.
It's good to be here. Thanks for having me.
Welcome to the Free Speech Zone, known as my podcast. So before we dive into Skokie, Illinois, tell us a little bit about FIRE. Changed your name. It's still FIRE, Foundation for Individual Rights and Expression. But recently you changed it from something else where you only focused on college campuses, but now you're doing everything.
Yeah, FIRE was founded in 1999 by a left-leaning civil libertarian named Harvey Silverglate, who practiced civil liberties and criminal defense law out of Cambridge, Massachusetts, and a right-leaning civil libertarian named Alan Charles Kors, who's one of the nation's premier scholars of the Enlightenment with an expertise in Voltaire, who was a professor and is currently a professor emeritus at the University of Pennsylvania. And they came together to found an organization that would defend free speech, academic freedom, due process, and fundamental fairness on college campuses for all students and faculty members, regardless of their political beliefs. And for 23 years, that's what FIRE focused on, is becoming the leading advocate for civil liberties and individual rights on America's college campuses. But in 2022, the organization saw a calling to become the leading free speech advocacy group for all Americans, taking our free speech mission off campus and doing litigation, legislative and policy, and public awareness around this fundamental American value. And so we've been doing that for about 2 years now and are trying to build a free speech army.
Is that because the ACLU has fallen off in that category a bit?
I wouldn't say so necessarily. The ACLU has 19 different issue areas. FIRE has one. We did see that there was a space for an organization like FIRE to kind of come in and take cases from average Americans who have their free speech rights violated while continuing to do the campus work that we have always done and that we've made a name for ourselves in. We partner with the ACLU where we can. We are right now filing an amicus brief at the Supreme Court in the case that the ACLU is litigating on behalf of the National Rifle Association, where New York State officials jawboned and pressured financial institutions in the state of New York to stop doing business with the NRA. So we partner with the ACLU on that case. Partner with the ACLU on other cases. We take the Frederick Douglass mantra to work with all to do right and none to do wrong. And we've worked with the ACLU for a while on that.
I ask because you're aware the ACLU has been criticized for not upholding free speech values the way it did when Ira Glasser and the others were defending the Nazis' right to speak in Skokie. So,
yeah, of course. Ira Glasser, Wendy Kaminer, some old school civil libertarians who've had long affiliations with the ACLU have their problems with the current ACLU, but I leave that fight to them.
So Skokie, 1977, and a fellow by the name of Frank Collin before we get to them, why don't we just go over briefly what the state of First Amendment free speech jurisprudence was before the controversy erupted. Actually, it didn't erupt in Skokie. Skokie started in Chicago. We'll get to that in a moment. But I think some folks might be surprised to learn how long it took in our country to establish what we would now consider to be your First Amendment right to say what you want, when you want, where you want. For instance, during the First World War, we had something called the Espionage Act, which really didn't crack down on spies. It was about cracking down on dissent and throwing socialists in jail and shutting down the socialist press. Why don't you pick it up from there?
Yeah, well, I'll just start by saying that the First Amendment was ratified in 1791. But it was only 7 short years later that John Adams and Congress passed the Alien and Seditions Act, which essentially criminalized criticism of the government. You fast forward to the 1830s and you get a gag rule in Congress that forbids raising, considering, or discussing slavery on the floor of the U.S. House of Representatives. And then, of course, you get the Espionage Act of 1917, which made for the criminalization of criticism of the government, of the draft. One of the famous Supreme Court cases is the 1919 case Schenck v. United States, probably most famous for originating the phrase falsely shouting fire in a crowded theater. But folks forget when they use that phrase what the phrase was analogizing, which was Yiddish-speaking socialists who were handing out pamphlets opposing the draft who were thrown in jail for doing so. I guess you could compare that to falsely shouting fire in a crowded theater, although you'd have many people who say that World War I was a very crowded theater and fire needed to be shouted. So
Eugene Debs was thrown in jail for giving a speech encouraging people to resist the draft.
Yeah, it's hard to believe it today, the number of Americans who were punished for anti-war protest. Yeah. But that's what the early 20th century in America featured. And you had another case in 1919, Abrams v. United States, which punished individuals who had circulated pamphlets critical of the United States government and its involvement in World War I. But that's also the case where you had Justice Oliver Wendell Holmes in a dissent first positing this marketplace of ideas theory that would then become used as the foundation or fodder for much of the Supreme Court precedent and cases that would come. And it was in the early to mid part of the 20th century that you get the First Amendment as it is currently interpreted. Up until that point, it was largely a promissory note. The ACLU was founded in 1920 in part because the First Amendment didn't do what folks hoped it would do. Its first annual report was called The Fight for Free Speech. Its second annual report was called A Year in the Fight for Free Speech. And you really got the First Amendment coming into full bloom with the Earl Warren Supreme Court and the Warren Burger Court from 1953 to 1986.
Not that long ago. Yeah, you're right about that. Yeah, ACLU was founded by Roger Baldwin and some others in 1920. The following year, Congress did repeal the Sedition Acts. 1925, there was an important court ruling, Gitlow versus New York. That was important because the court concluded that the First Amendment applies to the states as well because of the Due Process Clause of the 14th Amendment. I'll share, one other. There's so many cases. We'll spend all day on this, but I mentioned Gitlow in New York in 1925. Then in 1931, Stromberg versus California. First Amendment freedom of speech includes non-verbal expression. 1943, West Virginia Board of Ed versus Barnett. First Amendment prevents government from requiring speech just as it prevents government from limiting speech. I think in that case it was Jehovah's Witnesses who did not want to participate in something.
The Pledge of Allegiance.
That's right, yes. They did not want to have to stand and recite the Pledge of Allegiance. But so we can go on and on about that. Would you say then, by the time Frank Collin is trying to, actually, as I mentioned, Chicago, right? By the time Frank Collin is trying to hold marches, neo-Nazi or Nazi Party marches in Chicago, that the modern interpretation of the First Amendment is in place?
Kind of. So in 1949, you get a case, Terminello v. Chicago, in which is a Catholic priest said some unruly racist remarks and was prosecuted under a disturbing the peace statute. That case made its way up to the Supreme Court, and the Supreme Court held that the function of free speech is to invite dispute. It may indeed best serve its highest purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. 1971, you get a case, Cohen v. California, where a man wears a jacket into a court proceeding that says, fuck the draft. The Supreme Court upholds his right to do so, ruling that one man's vulgarity is another's lyric. But at the time of the Frank Collin attempt to march into Skokie with his band of neo-Nazis, there hadn't really been a lot of jurisprudence around hate speech. That would actually start germinating with the Skokie case and really come in to what we know today in 2011 with the Snyder v. Phelps case and in 2017 with Mattal v. Tam. But at the time, the city of Skokie justified a lot of its city ordinances on fighting words doctrine. It's important to kind of understand how fighting words doctrine originated. It originated with a Jehovah's Witness who called a police officer a goddamn racketeer and a fascist. And the court held in that case in 1942, Chaplinsky v. New Hampshire, that those were words that by their very utterance inflict injury or tend to incite an immediate breach of the peace. So that was the justification Skokie was using in part to go after Frank Collin and his band of neo-Nazis and prevent them from rallying.
Speech is violence. I've heard that recently.
Yes.
And also,
it's come back into vogue.
It wasn't
although
just...
it never really went out.
Yeah. Handing out pamphlets or putting out a newspaper. It was an assembly, a public assembly, and threats of violence, so there was a lot to it. Collin initially wanted to march in Chicago, right? He and his party were annoyed at efforts by the city to integrate neighborhoods, integrate schools. I know this from watching your excellent documentary, Mighty Ira. And the city of Chicago decides, well, they didn't want African Americans marching either in favor of integration. So the city of Chicago basically decides they're not going to let anyone hold marches in city parks.
Yeah, Marquette Park was a park on the south side of Chicago that was often home to rallies and protests. And the city of Chicago had ultimately decided that they were going to create burdens for people to use it that no one could really meet, including a multi-$100,000 insurance bond requirement in order to use the public parks. Now, the thing about those insurance bond requirements is that no insurance company will issue them. So effectively, folks were barred from holding rallies and protests in Marquette Park. Not just the neo-Nazis who were frustrated with integration on the south side of Chicago, but also the Martin Luther King Jr. coalition, which was being represented to oppose these insurance bond requirements by the ACLU. And in fact, the Nazis went to the ACLU to ask them to represent them in challenging the insurance bond requirements. But the ACLU said, we're already litigating this case, and if we win it for the Martin Luther King Jr. Association, we'll win it for you as well, because the principles, of course, are neutral. Neo-Nazis ultimately decided that they were going to try and host their rallies in all the white neighborhoods outside of Chicago that whites were moving to from downtown Chicago. And so they wrote a number of letters to all these cities requesting a permit to rally. Most of these cities ignored them, but the city of Skokie reacted like a bull to the red flag.
And we're talking about, 25, maybe 50 people who were going to participate in this march?
Yeah, Frank Collin's group of neo-Nazis was relatively small, although they had their own outpost in downtown Chicago.
Yeah, and they called themselves the National Socialists of America, basically the Nazi Party of America.
Yeah, I believe they're the NSPA, the National Socialist Party of America. They were a band of neo-Nazis without any real political power, but Skokie was home to around 6,000 Holocaust survivors. And so you can imagine the feelings they must have had when they heard that there might be some neo-Nazis coming to town wearing their swastika armbands. Many of them, of course, remember the real Nazis marching in their towns wearing swastikas on their arm and what that resulted in, which is, of course, the death of 6 million Jews in Europe.
And there are parallels to the Unite the Right rally. I think people will think of what happened in Charlottesville as they're listening to this conversation, where these white supremacists, white nationalists, whoever they were, went to protest the removal of the Robert E. Lee statue at the campus of the University of Virginia. I think there is a parallel there if we want to compare the reaction to both
What
cases.
happened in Charlottesville is very similar to what happened in Skokie, or at least the lead up to both of those events is very similar, You also had folks marching through the University of Virginia's campus saying, Jews will not replace us. You also had Jews will not replace us chants coming from Frank Collin and his group of neo-Nazis in Skokie in 1977. And in fact, the neo-Nazis had often clashed with Jews throughout the Chicago area. In many cases, those resulted in bloodshed. And of course, in Charlottesville in 2017, you actually got bloodshed. You didn't see it in Skokie because the neo-Nazis never ended up going to Skokie, even after they got a court ruling that said they had the right to rally there.
Yeah, so let's talk a little bit about that legal case, which is so important still today. The initial advice of Skokie's lawyers was that why don't we just ignore this? They can go and hold their 30-minute, march and say what they want. People don't have to attend it. Why did they change their mind and go to great lengths, all types of legal efforts to try to stop the demonstration?
Yeah, the city of Skokie ultimately changed its mind and decided to pass a number of new ordinances to stop the neo-Nazis demonstration, in part just because of the uproar that they received from their community. There is a saying in the Jewish community, never again. And so the idea that you're going to have this band of racist neo-Nazis marching through the community with swastikas on their arms was just too much for these 6,000 survivors of the Holocaust and their families to countenance.
What is prior restraint?
Prior restraint is a restriction on an individual or group of people from speaking before they actually speak. And the Supreme Court has held in a number of cases that this is the essence of censorship, the prohibition of suppressing speech before it is actually spoken or written. 1931 case, seminal case, Near v. Minnesota, the court concluded that this was the primary aim of the First Amendment, to stop prior restraints. And then, of course, you get the seminal New York Times v. United States case in 1971, just a few years before the Skokie case, where the Supreme Court allowed the publication of the Pentagon Papers, which the government tried to prohibit them from publishing. So this is a long, widely criticized practice of government censors, prior restraints, that goes back even further than the existence of the United States to 1643, when John Milton, in his famous treatise Areopagitica, criticized the British Licensing Act of 1643.
We're going all the way back to the 17th century here. Yeah. Today, that would be, as I call it, the speech is violence argument. I've had arguments with people about this. I went to a party a few years ago prior to the pandemic where somebody who was actually a journalist astonishingly believed in, you should be able to stop people because this is different. We can't allow these murderers to go marching anywhere because what they say is beyond the pale. And I tried to explain to this person that idea will be turned around at some point, and it will be used against people who you are on your side of issues. And we are actually seeing that today, wouldn't you say, Nico, with what's going on with pro-Palestinian demonstrators.
Ira Glasser, who became the executive director of the ACLU in the last year of the Skokie fight, 1978, likened censorship to poison gas. It seems like a good tool to marshal toward your enemy when the wind is at your back, but the wind has a way of shifting, and that poison, in this case censorship, has a way of blowing back on you. And one of the cases that he most likes to cite to demonstrate this principle is a Zionist student group in the United Kingdom in the 1970s. At that time, the student unions throughout the United Kingdom were wanted to pass a hate speech ban on college campuses. The Zionist students supported it, but a few years later, the student union decided that Zionism was a form of hate speech and was racist, and the Zionists themselves had that policy applied to them. So be careful what you wish for. Ultimately, free speech is an insurance policy. It might protect the right of neo-Nazis to rally in a town full of Holocaust survivors, but it also protects the right of Jewish war veterans to rally in that same town. And one of the things you saw in this case was that one of the ordinances that Skokie passed was a prohibition on people wearing military-style uniforms in demonstrations, which was used against the Jewish war veterans in Skokie. But it was only intended to have been applied to the Nazis. In America, we operate on neutral principles. We don't have free speech for me, but not for thee. The rules that I live under are the rules that you live under, and are the rules that the Nazis live under. Unless you want rule by an individual and the whims of what they decide is right and just and can be exercised, we need to abide by these neutral principles. And in fact, the longtime executive director of the New York Civil Liberties Union, Norman Siegel, said that if he could have any tattoo on his body, it would be the phrase neutral principles across his chest. Unfortunately, this principle has kind of been abandoned, unfortunately, in recent years, or isn't held in as high of esteem as it used to be, as we've succumbed to what I call the politics of expediency.
Well, and there's a moral panic as well. People can't seem to understand, some people, that defending somebody's right to say something does not mean you endorse it at all. I'm glad you brought up the military uniform thing, because Skokie did try a whole number of different legal tactics to try to stop the march. Something else, too. There was a preliminary injunction hearing. And matter of fact, I think the village of Skokie won. They won this hearing to stop the march. And one of the people who testified at that hearing against the Nazis' right to hold their march was a Holocaust survivor, Saul Goldstein. He said that we can't allow this because it's going to start violence. People will react violently to the Nazis marching through town, and we don't want to see a war basically erupt on our streets. That is called the heckler's veto. Why don't you tell me a little bit about the heckler's veto?
Yeah, the heckler's veto is a principle in law and in culture. So in law, it means that the government cannot censor a speaker because they anticipate a violent response on behalf of the audience. That runs contrary to the First Amendment. In culture, it's anyone who tries to use mob-like tactics to shut down a speaker, regardless of whether the government is getting involved to sanction that heckler's veto or not. It's just a principle in the First Amendment that we shouldn't condition our right to speak on how someone else subjectively responds to it. Now, the fighting words doctrine, right, which we talked about, the 1942 case, Chaplinsky v. New Hampshire, involved a Jehovah's Witness who called a police officer a goddamn racketeer and a fascist. And it said that fighting words essentially condition someone's speak on the tendency it might have to incite an immediate breach of the peace. But that principle has largely become a dead letter in the law as the First Amendment has evolved to prohibit that sort of heckler's veto. And now when we think of incitement, we think of the 1969 Brandenburg case, in which I believe it was a member of the Klan held a rally and said, we're going to take revengeance later against this group of people. The Brandenburg Standard says that incitement must be so imminent and likely that it'll incite an immediate breach of the peace and lawlessness. And so it's a very high standard. Even calling for lawlessness at some later date wouldn't meet it because you need to call for it imminently.
Yeah, because these definitions are so elastic. What is hate speech, right? What is incitement? When a politician goes up on the podium and says, I'm going to fight like hell for you. You know, we're going to march all the way to the steps of the Capitol and fight like hell. Does he mean that literally or metaphorically?
Yeah, and that's why any exception to the First Amendment is entirely fact-intensive. So in that case, when we're talking about Donald Trump's rally on January 6th, he did say peacefully march to the Capitol. Yeah. But you have additional facts that are introduced and say, well, the whole entire context and everything he'd been saying before suggested that what he was actually saying was that we need to go there violently and, you know, the fight like hell and the peacefully march. That was just all a dog whistle for what he really wanted, which was people to storm the Capitol. Now, courts have to litigate those fact-intensive questions. On its face, the rally itself and the speech he gave probably wouldn't meet the Brandenburg Standard as enumerated in 1969 because it's a very high standard.
Yeah, I agree.
But these questions are very difficult to answer and often involve a fact-intensive analysis, as you see in defamation law, as you see in cases involving fraud, and some of the other First Amendment exceptions.
I think the best way of putting it is that Trump egged on the mob, but if you're going to say he incited the mob, and I may have said that at some point in the last couple of years, that's a legal term. Politically speaking, what he did that day, the entire attempt to overturn the election, is a complete disgrace. But legally speaking, it would probably be very difficult to get an incitement conviction if he were ever charged. I mean, he has not been charged with incitement, as far as I know.
Well, some of the analyses that you see in states like Colorado, where they're removing him from the ballot, involve an incitement analysis, and the court in that case ruled that he ultimately did incite imminent lawless action under the Brandenburg Standard. This is a question that is in great dispute within the First Amendment community. There are many people who think he didn't meet the Brandenburg Standard, while there are some who are willing to argue that he did. But in all these cases, it is effect-intensive analysis. But we need to tether that analysis to the law and not engage in what I call, again, the politics of expediency, which is cutting down the law or creating shortcuts around it or whittling it out in order to get after the politicians or people that we don't like.
Back to Skokie. After that preliminary injunction, the ACLU appealed, and it was supposed to be a matter to be determined by the Illinois state courts. But they delayed. They weren't deciding. And the Nazi Party wanted to hold their march, and they're waiting for months. So the ACLU then appeals to the Supreme Court for some emergency relief, which was not something the Supreme Court did all that often.
What the ACLU and the neo-Nazis found was a state Supreme Court system that didn't take their First Amendment concerns seriously and weren't willing to expedite First Amendment review of their case, essentially to stay a court order to prevent the rally by the neo-Nazis. And so what the ACLU and the neo-Nazis did was appeal to the Supreme Court to force the state Supreme Court to order a stay of the order banning their rally. Ultimately, what the Supreme Court did was say that First Amendment rights were in play here. And when First Amendment rights are in play, you need to have expedited review, because absent such a review, every day that the neo-Nazis can't rally is a further violation of their rights. So all the Supreme Court really did was say to the state Supreme Court and appellate court, First Amendment rights are at play here. We need to consider whether this was a prior restraint, which, as we discussed in previous cases, the court had held to be the essence of censorship. And so it sent the case down to the state Supreme Court and the appellate court for further review. And what the state Supreme Court ultimately found was that public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some of their hearers. And they relied on that Cohen v. California case to justify that determination. And the Skokie case ultimately became one of the first cases to develop the principle that hate speech isn't an exception to the First Amendment.
And there's no question it was hateful in this instance, and that it would cause emotional harm to the Holocaust survivors. But there was another principle at stake as well. Ultimately, what happens here is the Nazi Party wins, as you just said. They win the legal case, but even the ACLU is warning them, hey, if you go ahead and hold this march, there's a chance you're going to be attacked in the street. And the village of Skokie gets desperate, and they appeal to the Justice Department for help. Long story short, the Justice Department talks to Frank Collin, the head of the party, head of the Nazi Party, and he agrees to take the march elsewhere. He never actually holds it in Skokie. Collin asks for some things, right? He has a list of requests that he wants met if he's going to move the march, and one of them was that the Illinois General Assembly repeal a piece of legislation to ban what he wanted to say.
Yeah, it's widely believed that Frank Collin didn't really want to march in Skokie in the end, that he and his band of neo-Nazis were maybe afraid to do so. So when the Justice Department got involved and brokered a deal between Skokie, the ACLU, and the neo-Nazis to allow the neo-Nazis to rally in the city of Chicago, he was eager to jump on it. And he had the excuse to do so, right? One of the original reasons he wanted to rally in Skokie, Illinois, was because he could not rally in Marquette Park on the south side of Chicago. So when he got that right, he did so. He first rallied in another place in downtown Chicago, but then ultimately he got into Marquette Park, had his rally, and it was just like 12 to 15 of them.
Exactly.
And it's
like
actually,
if you just ignored them to begin with, none of this would have happened.
No, none of it would have happened. But what you saw when he did get to Marquette Park was a phalanx of police officers protecting the counter-protesters and the neo-Nazis from coming to fisticuffs with each other. And that's what you didn't see in Charlottesville in 2017, is you did not see the police presence that was necessary to maintain the peace. And so that's why I believe you saw violence in Charlottesville, and you didn't see it when Frank Collin arrived in Marquette Park in 1978.
And there are a lot more people in the Unite the Right rally than there were when Frank Collin held this pathetic little march at some point there.
But even if you review the footage and accept the premise that there were a lot more people, you see these clashes and you don't see a police officer in sight. And when I was reviewing archival footage for the Skokie case, And all of the various rallies that the National Socialist Party of America was holding, you saw police officers everywhere. There was a show of force that they were going to maintain order. And that's the job of the police, right? It is to protect our constitutional rights, even for the more hateful among us, because that's protecting their rights also protects everyone else's rights. So if we're going to spend money on anything in the United States of America, it should be on the protection of constitutional rights, even if that means a large police deployment.
So I look back on this as you do. The ACLU, they were heroes for defending the First Amendment in this case. But their membership and the public didn't take kindly to this, right? What happened to the ACLU after this imbroglio died down? I think in your documentary, Ira Glasser said his priority went from civil liberties to institutional survival.
Yeah, the ACLU was facing two headwinds when Ira Glasser became the head of the ACLU in 1978. The first was that the ACLU got involved in the impeachment of Richard Nixon. And this mobilized a huge constituency to support the ACLU's efforts to impeach Nixon. So it brought in a lot of additional financial support, and the ACLU expanded its organization as a result. But when Nixon was finally impeached, all the people who came in because that was the cause they cared most about fell off and did not renew their memberships. But the ACLU was still the organization that it grew to become, and so it needed to fill that hole. But at the same time, you have the Nazis in Skokie case. A lot of the ACLU's Jewish supporters decided that they could no longer support the ACLU as a result of that advocacy. And Ira Glasser, who was formerly the executive director of the New York Civil Liberties Union, felt it acutely because the New York Civil Liberties Union had the highest number of Jewish supporters. So folks were writing in and day out saying that they were canceling their membership. So that was creating financial pressure on the ACLU. And the ACLU didn't really see it coming, even though that they probably should, because the Nazis in Skokie case was the type of case that the ACLU took once or twice a year. It was routine for them. But the facts in this case spoke to a larger story, of course, the story of what the Jews experienced during the Holocaust and the fact that 6,000 Holocaust survivors lived in Skokie, Illinois, captured headlines and made this case something that was far from routine for the ACLU.
It became a national story,
Yeah, it made it a national story. Jimmy Carter commented on it. Ultimately, the ACLU was able to recover by David Goldberger, the lead attorney in the case, writing his famous Goldberger letter, which was a letter that laid out the principles for why the ACLU took the case in plain English. It wasn't overly legalistic. It made the case for neutral principles. They mailed it out to all of their supporters, and it actually became the ACLU's most successful fundraising letter to date and is largely credited with turning around the large exodus of money from the ACLU as a result of their advocacy in the Skokie case. And folks can find that letter, and I think it might be the only place where you can find it online. I shared it a while back, but you can see how powerful it was to have a Jew himself, David Goldberger.
Yeah. And where'd you say people can find that letter again?
Well, it's on my Twitter account. I posted the full thing, or X, formerly known as Twitter.
So, college campuses. How should the Ivy League presidents have answered in that congressional show trial? I'm still astonished that Ivy League presidents, so some of them are former presidents now, 2 of the 3 have lost their jobs. I'm astonished that they were outsmarted by a bad faith political actor, Elise Stefanik. I thought that their answers were phrased terribly and insensitively, but on the issue they were right. Context matters, but what did you think?
Someone said that the college presidents answered from the thesaurus when they were really being asked to answer from the heart. And I think that's a good encapsulation of what transpired on that day in December of last year. Ultimately, the college presidents got the answer right, that when we're talking about any category of unprotected speech, context does matter. Now, these are private universities not bound by the First Amendment, but all of them have committed themselves in their policies to First Amendment principles. Indeed, the next day, Liz McGill, the president of the University of Pennsylvania, said exactly that the University of Pennsylvania, in its policies, committed themselves to First Amendment principles and that they were going to reevaluate those principles in light of the congressional hearing. I think that was a bad move, and ultimately Liz McGill resigned. But the question that they were asked was, do calls for Jewish genocide, are those unprotected under your school's policies? And they answered, context matters. But you can understand why context matters if you just look at the discourse surrounding the Israel-Hamas war right now.
Of course.
You have folks on one side accusing Israel of committing an act of genocide. You have folks on the other side accusing Hamas of attempting to commit a genocide. You can even broaden it out. You have accusations that Republican legislatures, in passing laws banning gender-affirming care, are committing an act of genocide against trans kids. You have pro-lifers saying that abortion is an act of a genocide against the unborn. So if you untether these principles from the law, then you ultimately get just rule and decision-making by those in authority, and they'll determine what a call for genocide is and whether that meets a standard for harassment or incitement.
Yeah, the list of sentences that people are not allowed to say will continue to be added to. You can't limit this type of thing to one set of ideas or one sentence. My problem with that whole thing was, well, first, Stefanik lied. There aren't groups of pro-Hamas demonstrators or sympathizers marauding around campus threatening to kill Jews. Okay? If you go up to somebody and scream in their face, "You Jew SOB, I want you to die," that is different than holding a rally in support of Palestinians where you say, "We want Palestine to be free from the river to the sea."
Or intifada.
Or
there is
intifada.
a standard for peer-on-peer harassment as articulated by the Supreme Court in a 1999 case called Davis, in which harassment needs to be severe, pervasive, and objectively offensive in order to and effectively deny a student the right to an education. One merely shouted from the river to the sea, Palestine will be free, will not meet that standard. But as you say, getting in someone's face, following them out of class, and shouting that phrase repeatedly might indeed constitute peer-on-peer harassment and could be punished. So the presidents were right when they say that context does matter. Now, we need to understand also that this was a political hearing and that being a college president is a political job. For better or worse. It's a job in which you need to do a lot of things, including fundraise and be a representative of the university. And I think the lawyers got in their ear too much. And as a result, they gave an overly legalistic answer to a question that was more focused on trying to get them to speak from the heart. But I probably would have said the same thing because I approached these questions from a legal perspective as well when we're working with colleges and universities to reform their policies. But that's why I'm not a college president.
Yeah, well, one issue I want to raise with you here is what I think happened as well is that many colleges, or at least in the case of the few that were testifying that day, it was brought up that, hey, you've been cracking down on speech that is hostile to marginalized groups, that there are protected groups. And if on a college campus, either you or you invite a group or a person to come onto your campus to say certain things about whoever, transgender, any marginalized group, you can get yourself into a lot of trouble.
Yeah, colleges have been very sensitive to accusations of bias by a number of different minority groups throughout the past decade. Harvard did a mandatory training where it said that evidence of fat phobia is violence.
Yeah, exactly. That's what I mean. I mean, it's ridiculous.
Yeah. You see college campuses saying you shouldn't do yoga or eat sushi because it's an act of cultural appropriation. Harvard drove a lecturer named Carol Hooven from campus because she went on Fox News and said that biological sex is real. So you see all of these examples of speech suppression at Harvard, at the University of Pennsylvania, at MIT, when other groups are targeted. But then you have Jews and they say, well, context matters. Well, what you should have is censorship in none of those cases.
Yeah, exactly.
You shouldn't have double standards. You should have free speech standards. And so you could sympathize with those who see this hypocrisy and say, what the heck?
Let's wrap up here, Nico, with something that I think is so important and is often overlooked. We talk about the First Amendment a lot, but free speech is a cultural value. People should be free to destroy their own reputations, you know? So
yes.
If you want to march around with a swastika on your arm, feel free. Somebody will take a video of that, put it on social media, and then you can expect to have that hanging over your head for the rest of your life. Do you think this problem is overstated? I mean, you would know. Is there a hostile culture to free speech in our country now?
Well, it certainly seems that way. And if you look at the current polling among young people, they seem to be increasingly skeptical of free speech principles. FIRE conducts an annual survey of college students across the country, the largest annual survey of college students about free speech principles. And this past year, we found that some 30% of college students believe that violence could be justified in some cases to prevent a speaker from speaking on college campus. And that's a shocking statistic.
Does that go for them? Would they be okay if somebody beat them over the head if they were...
Probably not.
Yes.
This goes back to Nat Hentoff's civil libertarian principle, free speech for me, but not for thee. Very few are the people who understand that free speech needs to be applied to their ideological opposition or their enemies as well as to themselves. Nat Hentoff also said that free speech is the second greatest instinct in humans next to sex. Excuse me, I said that backwards, that censorship is the second greatest instinct in humans next to sex. So people just have a natural instinct to want to censor, to want to shut up the people that they disagree with. But one of the ways that civilization has been able to come into existence is through free speech, is through mediating our differences through words, not violence. Sigmund Freud is once quoted as saying that civilization started the day man cast a word instead of a stone. And I truly believe that. And if we're going to have a democracy, which depends for its very operation on talking across lines of difference and finding compromise in order to come to resolutions on important questions within this country, we need to have the ability to talk with each other and talk across lines of difference. And I fear that we're losing that in this country, particularly amongst young people who see speech sometimes as an act of violence. If you eliminate that distinction, you eliminate the ability to engage in the kind of democratic project of deliberation.
We can have conversation or violence, or you might say argument is essential to maintaining democracy. Nico Perrino of Fire, and the documentary again is Mighty Ira, available on Amazon Prime Video and other services. On the next episode of History as It Happens, it's the historians versus Donald Trump, the 14th Amendment, and insurrection.
Let's have trial by combat.
That's next as we report History as It Happens, a podcast from the Washington Times.